Good evening, everybody. Welcome to the last session of the day at GEW. My name is Eric McNair. I work here at the University of North Texas Health Science Center, and I am so happy to be here to be able to talk to you about intellectual property today. I'm here with Mike Give
it a shot.
So I was practicing this.
Krozenic.
It's Krozenic, right?
You got it.
So we're going to talk to you today about what to know about patents, copyrights, trademarks, trade secrets. And I promise you by the end of the day and the evening, you're going to have a lot more knowledge about the different types of intellectual property, as well as have some stories, because having a good base of knowledge is that's what we're about. So we're going to make this as interactive as possible. So we have today, we're going to use this Slido app. So please, if you will, get your smartphones out. I'm going to encourage, most speakers will be up here and say, put away your phone and don't check it. I want you to participate, because this app is going to give us the ability to take questions from the audience, as well as we're going to have some interactive polls in the interim. So I hope you do participate. And in most cases, you can vote more than once, or you can have more than one response, okay? So also, we want to encourage interaction. So if at any point during the presentation, if you have a question, just raise your hand, and we have a mic that can go around, or this is a small enough room, let's be honest. We could just, we can yell it out, right? So let's get rolling. Here's the code in case you didn't already have that. And I put this, when I put it together, that you needed to have an app, but you don't need an app. So for the first poll, I want to understand kind of the test of the audience and what is your experience with intellectual property. And as we're talking, you're going to see this real time come in. And I want to just get an idea whether you know the value of IP and can name more than 5 inventors off the top of your head. You may have heard about one intellectual property one time in the news. I'm green. I've never really heard anything about its value, or I'm a pro and I have an active IP portfolio. So we really want to kind of get that. So as those are coming in, just as a show of hands, who knew that there was another IP session yesterday? Okay. Did anybody go to that IP session yesterday? Okay. So we really like to know about intellectual property. Very good. I like this. Well, then we are still coming in. We got 13. Good. So yeah, it looks like we know the value of IP and can name more than 5 inventors off the top of my head. That's good. All right, thank you for that participation.
Can I talk?
Yeah, go ahead.
Yeah, can you go back to that last slide? So the thing I love about this, the thing I love about this thing is we're not here for the pros right now. If you want to ask the pro type question, we can totally answer it. Don't even worry. Don't even hesitate. Everything else is about where this presentation is. So I think this is a really good set. Yeah, I hate, you can hear me like this, but this is for the video, right? All right, sorry. I hate the echo. That's good. So yeah, let's jump in. Go to the, I got to get the clicker, right?
Yeah.
We're sharing clickers, right?
Right, we're sharing clickers, so you can go ahead.
There we go. I'm going to drive for a little bit, and then Eric's going to jump back in and drive, and then I'm going to drive, and then Eric's going to drive.
Collaborative effort.
I'm Mike Krozenic, and I'm a patent attorney. I've been doing this for 20 years. I love ideas. I love patents. And I used to do litigation. I don't like litigation. I am something called a prosecutor, and that just simply means I create content. I'm the person who creates patent applications. The litigators, with much love, much respect, they take my content and destroy it, and they rip it apart. I don't do that. I do the litigation. I do the prosecution part. So The goal here, this is kind of the whole lecture or the presentation we're talking about. We're going to hit these 5 topics, and we kind of presented it as like, what's the big 5 questions that people ask, especially entrepreneurs, people who are newer to the IP world. And these are some of the big 5s that I've seen over the 20 years. What is IP? Is IP valuable to my company? I think everybody should answer yes, but we're going to give you rationale why the answer is yes. What's the best form of IP protection? And as the typical attorney, it depends, and we'll figure out why it depends, and it'll make sense. Some of them can cross both lines, but it depends. When do I disclose my IP? Eric's going to hit that one, and it is a big one. Don't do it too early. Make sure you have the right things in place. I've seen it from entrepreneurs all the way up to mid-cap companies disclosing stuff they should not disclose. I'm going to California in a couple of weeks to sit in with scientists to say, don't disclose the trade secrets of the company. It's a big deal when to disclose. And then should I develop an IP strategy? The answer is going to be yes, and we're going to give you rationale for it. So let's jump into what is IP. So go online. Go online and look at the definitions. What is IP? You get these crazy definitions. You get these definitions that are like 15 sentences long, and they make no sense. And I found this one that kind of is simple. It's not my definition. Intangible creations of the human intellect. It still kind of doesn't make a lot of sense to me, right? It still seems kind of nebulous. And I was thinking about this question more than anything else. I'm in Austin, and I had a 3-hour drive up here, and it was awesome after 2 years sitting at home. It felt good getting out. And I was thinking about this question. What is intellectual property? Intangible creations, that doesn't make sense. I feel like intellectual property is simply, in one word, creations. Creation. What type of creations are you making? That gives you the types of intellectual property that's typically protected. So you have all these crazy definitions online, but I feel like intellectual property boils down to creation. So one type of creation is an idea. What's your idea? Idea, a chair. My chair is an idea. I want to patent a chair. You come up with an idea for a chair, it's a patent. It tends to be a patent. And this is just a couple quick fun facts, and we're going to hit patents harder in a few slides. But first patent, 1790, to potash. Potash is for agriculture, and it's still highly relevant today. Even in today's global economy, there's a shortage right now, and guess what? Potash, potassium. There's a shortage on agricultural nutrients. George Washington signed it. It's kind of interesting. The most recent patent out of last Tuesday was IBM patent. I have no idea what it is. My background is biochemistry and cell biology. This is all computer stuff. But I think the thing that I brought that up for is patents issue every Tuesday. First one, 1790. Most recent one as of last Tuesday, 11,166,401. I did the calculation. It's about 48,000 patents a year that are being issued. But you know the ramp up is way more, right? They weren't patenting a lot back then. They're patenting a boatload now. So you got to understand that as an entrepreneur, why are people patenting? And we're going to go into that. All right, we'll go to the next slide. Any questions? Ask questions, please, please, please. Don't even hesitate.
Or use the
There you go.
Biochemistry and cell engineering?
Yes, sir. Yeah, I mean, afterwards we can talk, but I completely stumbled into patent law. I didn't go to law school for patent law. I had no idea it existed, and I'm so happy I found it. It's a beautiful discipline. I love biochemistry, and I love law, and it's a great, great combination, synergy. So again, what is intellectual property? I feel like it's creations. You have ideas that are patents. The other kinds are literary works, product literature, product packaging, marketing materials, art, music. That tends to be copyrights, and we're going to give you the specifics on copyrights and how you can protect your copyrights. Another idea, and this one's important, especially for the entrepreneurs, please, please, please listen. Processes, data, employee lists, company lists. What else do I have here? Computer processes, business, manufacturing processes. These are trade secrets. I love trade secrets. Keep it a secret and you already have intellectual property. And if you have third parties coming in to look to acquire the company, they love patents, they love trademarks, they absolutely love trade secrets. And we'll get into why they love trade secrets so much. Yes, sir?
So could a data analysis stream, taking like genomics data and coming up with a new way to process it, could that potentially be something
You answer the question, because it's a loaded question. I know you know the answer.
No, I don't actually.
Okay, the answer is wildly yes. It's a fantastic question, and I would say the reason why I said that is because you nailed it. I would feel that's more of a trade secret than a patent. It might also be a patent, but that's a big-time trade secret, and you have intellectual property.
Mike, could you repeat his question for those who are going to be viewing?
You want to?
Yeah, I can.
Yeah.
Yeah.
I'm usually only good for one thing.
Me too.
So we're doing a genomics project, and we're having to create a new data analysis stream for our results. So would that count as intellectual property if we create this new data analysis process?
The answer is 100% yes. I feel it's a trade secret. However you guys organize it, wherever you're working, I would also fill out an invention disclosure form and let the attorneys decide whether they should file a patent on it or keep it as a trade secret. 100% that is intellectual property.
And then one real quick follow-up question. So I'm an academic, and usually I have students involved.
Don't publish first. I'm an
Okay.
attorney.
Yeah, okay.
You're jumping slides.
I know you guys. You guys are wildly brilliant, and you also want to let everybody else know about your ideas. And I'm down with that, but please, let's protect it first. Yep. All right, last one. Again, creation, product names, company logos. Those are the trademarks. So we're going to hit this lecture. I keep calling it a lecture. This presentation, we're going to hit all the different creations. And I think I'm still going one more slide, or is this you?
This is you.
All right, is IP valuable to my company? Say yes. It's 100%. Yes, right? It has to be, because if it's not, what happens? What happens if you come up with a new idea and it's a brilliant idea? What typically happens? Third parties will copy you immediately. How do you stop them from copying you? How? Just say it. That's right. You protect it with IP.
IP, good job.
If you get nothing else out of this lecture, that is it right there. If you do not protect your IP, especially as entrepreneurs, you are becoming the R&D for the big-time corporations. And here's the crazy thing. They're only going to take the good stuff. They're going to ignore the bad stuff. So please understand your IP is central to your new ideas, central to your new company. Without telling other people, get out of my space, they will get in your space and they will copy you, and then you will be out of the market. That's your leverage point against the bigger companies. That's your leverage point to grow a company is IP, in my opinion. I'm a patent attorney, I'm biased on this, but I've seen it many, many times with companies. So the other one, if you do have IP, it creates leverage with third parties if they want to get into licensing negotiations or they want to talk with you. If you don't have IP, again, they'll copy you and they might not want to invite you to the table. So the big one, though, is it prevents competitors from using your ideas. It's that competitive advantage. It keeps people out of your space. Valuation of the company, it's almost the same thing as competitive advantage. If I can copy you, I'm going to copy you. If I can't copy you and I need to come to you for your idea, the value of your company goes up. So the more IP you have protecting your company, the more valuable your company becomes, because the harder it is to copy you. And if you have a really, really good idea, the IP becomes more and more important and the value of your company comes up. I'm not saying that IP is the value of your company. The IP, the idea that you have for your company is why people are interested. Just protect your idea through IP. And that IP helps protect the value of the idea. And then, maybe not for entrepreneurs so much, but I've seen it many, many times. It's a marketing tool. You can say patented, patent pending. If you have a slide deck for a pitch deck for a company, it's great to say, you got patent pending. Stay away. Or somebody looks at your new product, and I want to copy you, and there's patent pending on there. Let's look at the company first. So yes, it's wildly valuable. Eric, I think you're up, man.
So we're not going to talk about genomics tonight, but we thought we would talk about, let's talk about something that we all can relate to, right? So I've got another poll. If you take a look at it, you've got, it's a Gillette Fusion 5, I believe, razor. And the question is, in 2 words, what do you think is innovative about this product? And as those responses come in, you'll start seeing a word cloud populate behind me. It should. So don't be shy. And you can vote, you can do more than once. But while you're doing that, I want to talk to you that we're going to we're going to be talking about, because I'm big in stories. So if you know me, then you know that I like to illustrate with examples. So with this question about why is it important, I thought we would talk about, not 5 minutes, about this story of Gillette. As some of them come in, nobody is saying, because we got convenience up there, multiple blades, Gillette commercial, okay, good. Unisex, renewable, modularity. There's some good responses. Yeah. So what do you think is innovative about that product? And you can keep going as I keep talking, but you get the idea. The answer is all of those things are the right answer. But the story goes back, if you could think back into the 1900s, before King Gillette invented the safety razor, you had a single blade and a strop, right? And the problem was you would have to sharpen the blade because it would get dull. And so it would, just like you see in the old cowboy movies, that he was outside, the barbershop would be outside with a leather strop and sharpen the blade. Well, it wasn't until a U.S. inventor invented the safety razor, and that changed everything, because what you now had, you had a handle and a disposable head, right? And so now you had, this was invented in 1915 by a gentleman named King Campbell Gillette. And lo and behold, he started a company. And so once he did that, he also was a tremendous innovator, because not just did he have the idea, but he was a great marketsman. Because back in World War I, he had an license to the United States military, and he was able to include each one of his products, of his safety razor, into each soldier's, and made it standard issue. So now you were talking about an exposure of one single product. And so when he first introduced, and I actually had this written down because I wanted to get it right. So when he first introduced the safety razor in 1903, he sold 51 razors and 168 blades. And 1 year later, he sold almost 91,000 razors and 123 blades in 1 year. So you can see the exponential growth as that did. And the genius marketing struck was that deal with the military. So here we are in the 1900s. You have the safety razor on the far left, and you can see there was 100 years of innovation. And throughout here, there was so many different improvements, and it was everything from all the things that you said, the blades, the handle. And the really interesting thing is, if you go look, it was actually 75 years until someone decided, let's introduce a second blade, right? And that almost was, and it's a good history lesson. It is just almost, you've got all these different types of innovation, but almost everything is innovative. You're always iterating in your companies, and you're always improving. And so up until 2019 was the last version. If you're familiar with that, it's this one on the far end. Anybody want to put a guess on what the most innovative idea they've got now? I'll give you a hint as this comes up. It has a magnetic rechargeable base, and it also is heated. So for only a mere $150, you can have your own heated, magnetically charged razor. And it is supposed to stimulate a barber shave, like with a hot towel. So tremendous innovation. And this next slide is going to demonstrate at least how many inventions. So we chose this slide because this kind of is going to talk about all of the different types of protection in one single product. You've got, and I'll walk a little closer here, but you've got the blade geometry and the blade coating. And there's utility patents on the retaining clips. There's cartridge design, has a design patent on it. You've got guards and lubricating strips and all of these different things, the handle. And in addition to that, trademarks. You got trademarks, there's trade dress, and all of these things that we're going to talk about. We're going to dive in a little bit deeper now. I'm going to respect everyone's time. We're going to get out of here at 5:30, I promise. But the story's not over. Once you have your IP, there's still there's still a secondary thing. You have to enforce it. So you have, in addition to the protection, you've also got to spend money to enforce, right? Because you're going to have competitors, you're going to have people coming, and so this illustrates that just because you've got the competitor on the right and Gillette on the left, and just because they added a fourth blade, everything else that was identical, it still constitutes a patent infringement. And so this is kind of a good lesson in a very simplified product of all the different things. So we're going to talk about the best forms of IP protection. Okay, you have a question? All right, let's get the mic.
So when there's like super complicated products that you're trying to patent and stuff, is it better to try to get a bunch of claims on that one patent, or to issue like continuations of the patent so that you have multiple patents covering multiple different?
That's a really good question. That's a really good question. I think they call that fencing, and where you have a instrumental. There's a lot of different approaches. I'm going to give my response, and then I'm going to let the expert respond as well.
That's a great question.
It's a really good question. And so one of the approaches that you can do is if you've got a good design, then you have, so patents are time limited, right? So you can constantly, once you have a great idea, then you can put that instrumental patent out first, and it takes time and it takes money to do that. But you may or may not get it. But during the interim, as Mike had previously put, you can slap the patent pending on your product, and that's worth a lot. And as we're going to cover later, once you have intellectual property, you also have leverage, right? You have leverage in your company in your different products, because if I'm looking at a product and I happen to be a venture capitalist and I know that there's a patent pending on it, I'm more likely to maybe invest in it, right? Because there's some protection. But to answer the other part of that question is, actually, I'm going to stop at that point, because there is the legal side of that as well.
Yeah, so that's a loaded question. So the reason why it's loaded, you must have answered like you have a good idea of IP, because you can't say you don't know IP, but to ask that question. So if it's one idea and it's a really great idea and it's very specific, I would file a patent application on it. If there's multiple ideas that are somewhat related, I may file one application on it, or I might file two applications on it. What you were getting at with the continuation, let's just say we filed one patent application and we got a kind of narrow claim. We'll go to the Gillette razor. The claim is to 3 blades. And like, all right, then you do a continuation and try to go for 2 blades, and then try to go for 1 blade. And I call it the bullseye effect. You try to go narrow first to get your product covered, and then you use the continuation practice to go a little bit broader, and the continuation practice to go even broader, and before you know it, you've got almost like the symbol here, but you got a bullseye effect. And the beauty of that is you absolutely have a bunch of different patents, narrow patents, broad patents, and when you have investors and third-party acquirers, they love it. They absolutely love it. The bullseye effect works like nobody else's business. You have a loaded question, and it is a big, passionate answer of mine. Go narrow first, broader, broader, and broader. And I guarantee you, those second, third, fourth continuations become very, very easy to get with the examiner because they're already sold on the technology. Yeah.
And later in the presentation, we're going to go after IP strategy. So we'll touch on that a little bit as well. Great question. So what I've put it, so the answer is, what is the best form of protection? And the answer is, it depends. It really depends on what is being protected, and we're going to go in a little bit more detail on each one of these. So copyrights is the first one I'm going to cover. It's basically, it protects the expression of an idea, right? Or expression, not an idea, sorry. And great thing about copyright is it's free. So everyone in here can be a copyright holder. In fact, you probably are a copyright holder and don't even know it. But the criteria is originality. And the protection exists as soon as it is fixed in a tangible medium. That could be a recording. It could be paint on an easel. It could be notes in a notebook or even a bar napkin, but that is your original work. And it protects against unlawful copying other people. The duration lasts for the life of the author plus an additional 70 years. And that's all what's great about that is, that's a lifetime, right? It protects it protects paintings, illustrations, photographs, books. I've got all these things up here. And all you need to do in order to get your copyright exists, but it's good practice to include the copyright symbol so that you have your attribution in place to notify the world that you have your copyrights. You can register with the U.S. Copyright Office, that is the governing body, but you don't have to. But if you are in business, the advantage of registering, and all that means is to include a copy of your work in a file at the U.S. Copyright Office. And so that now establishes precedent that you're the owner. But you have a public record of ownership, and now you can sue for damages if there's infringement. So one other thing on this slide, I went back about the duration of protection. Anyone know why there's, instead of the life of the author, it's additional 70 years?
Actually, I had a question.
Oh, okay. Well, let's wait.
I've heard that the risk on doing some of the copyrights or putting things out there, I guess, to be officially filed with the government, is that then it's public record. So then an individual could search it and then modify it slightly and then take that idea. So what are your kind of rules of thumb to know when you want to put it out there, that it's a public record, and when you want to keep it within your company?
Yep.
Does that make sense?
Yeah, that's a good question. It's a good question because it does become public. And I'll answer you this way with my own story again, right? So if I am standing and I'm taking a picture of the Fort Worth courthouse with my camera, and you have your own camera, or I even hand you a camera, and you take the exact same picture from the exact same spot, we both have the same copyright. We both have a different copyright. One is my creation, one is your creation, right? So one of the ways that in industry you can protect against knowing that someone has copied against you, there's some really cool tricks in the business, and one of them, my favorite, is with maps. That's why map creators oftentimes will put in phantom roads or phantom road symbols that only they know it doesn't exist, but they know that they put it in there. It's kind of like with silicon chips, they included microscopic images, or even on a very microscopic scale on their circuit boards, they'll have like cartoons, so that everyone knows that if it did come, you could say, look, I know that was mine because there's my phantom road. It doesn't exist. So good luck. So it's a good question, and but the fact is if you don't file with the U.S. Copyright Office, you can't sue for infringement. So if you were to keep that to yourself, then if your competitor filed instead, then they would have the upper hand. Mike, you have anything to add to that?
Yeah, I do. I want to put you on the spot again. You got to ask your question again. It'll answer your question.
Yeah. So a novel way to analyze genomic data.
Yeah, whatever you come up with and put on paper, that's copyright just like that. But I was telling you, I was screaming at you, do trade secret, trade secret. Maybe you do a patent, but do trade secret. To answer your question, do you want it out there or not? So if it's more of a trade secret, if it's more of an algorithm, if it's more of a computer program and you want to keep it a trade secret, Google rank. It's a copyright, but it's also a trade secret, so maybe you don't register with the patent office. It's completely up to you. What Eric was saying, it's good. It helps you to enforce, but sometimes you might choose not to do it because you don't want other people to know exactly what your copyrightable material is because you don't want them to take it or use it, but more specifically, make it even better.
I guess one of the things that in the pathway might be, would you get more value by putting it out there and allowing people to use it in a licensed way so you get credit for it?
It's up to you.
Or do you want
In a
to?
licensed way sounded interesting, but free use doesn't sound interesting to,
Yeah, okay.
a lot of business folks.
Well, maybe that's the driver. What, I'll be creating a lot of. I'll be creating a lot of intellectual property, which will be processes and methods for them to improve their business. So I will need to share it with them to help deliver the business value. But I don't want it to where somebody can just go and copy it, because then we lose all the business value. It sounds like I may need to really think about licensing.
Possibly, but we'll get into it with confidential disclosure agreements, non-disclosure agreements, where you can share information, but it keeps it a secret as well.
Okay, thank you.
And-
Yeah, because it's not like it's not something that'll be kept inside the company, like the Coke recipe.
Exactly.
It's something that for it to add business value, I need to be sharing it with my clients and implementing it with them.
Do it under a confidential disclosure agreement.
And one more point I'll say on this. This is a good topic. Copyright, each one of these that were in the different matrices, we could spend another whole session on. But what I will tell you, one more thing that you have available to you as a copyright artist is there's, instead of copyright where all rights are reserved, there's something out there called a Creative Commons license, which is some rights reserved. And that is also gives you license. It's out there. It's a great tool. And if you want to learn more about that, I'll be happy to talk to you about that. Okay. Do we answer your question? Okay, good. Going back to my earlier question about the reason why we have 70 years instead of the life and the offer, because why you would do that is Walt Disney was able to petition Congress. And so he was able to protect Mickey Mouse and all of the characters. So forevermore. Another type of protection is trademarks. This is a form of protection that protects the words, names, symbols. It can be sounds. It can be colors. It can be. This is a really great way to protect, and often overlooked in business. But it's a source-indicated word symbol, and then the criteria for protection is that you got to be distinct. You got to be distinct in commerce. To obtain protection, you're actually going to use it. So you can't just not use it. To maintain your protection, and it protects against confusion. And the duration, it will remain protected as long as you use it throughout in commerce. The other big takeaway here, I'll just kind of run through this fast, is there's two forms of trademarks. There's what's called the common law trademark symbol that's used for unregistered works. And then when you file with the USPTO and you go through the process, and it's an involved process, you could get this registered mark. And once you have that, then you're putting the world on alert that you have a registered trademark. And then this is kind of a fun exercise, but I'm going to, top symbol, what is that? Just shout it out. Okay, second. Third. The next one. And the last. Good job. So you all pass. And this demonstrates the value of all these companies. So it took maybe 30 seconds to go through that, right? And that's because everyone has this symbol and they recognize it. So you as a company should think about that. So I'm going to talk to you just real quickly about a symbol you might not know, and that's this. This is called a emoticon frowny, but did you know that it was registered trademark? Yeah. So guess what? If you've ever used that in email, you've infringed against this trademarks. You've done that. Yes.
I heard that the happy birthday song was, I don't know if it's trademarked or what, but that it's like protected, and so legally we're not supposed to be singing happy birthday, yet we all do anyways.
Yep, I've heard that too. I don't know the validity of all of that because it's been used in the different renditions, but I've heard that. I've heard that as well. But go to any restaurant in town, and they've got their own version. So, but going back to this was actually started by a company in Dallas, Texas. Right. And I've been using this story for 10 years. And I didn't realize, well, I knew it was in Dallas, and who knew I was going to be close to that. But the company was called Despair.com, right? And so they use this as their symbol, just like Apple uses the apple. All right? This is real, y'all. I looked this up, and it's still in effect. So this is a screenshot of the trademark electronic search system. And you'll see that they've got, the registration, and it's been in force. So down here, this was November 4th, 2021. So what this guy did was he really wanted to test the idea. I said previously that anything can be trademarked, really. Sounds, colors, everything. So he wanted to push that to the limits. So in 2001, and this was registered in 1998, he sent out this email, and he basically said, guess what, everybody? I've got this registration, and I'm going to start enforcing it. So I'm going to read this to you. He said, through the use of FBI's controversial new carnivore internet wiretapping system, serendipitously monitored unencrypted internet emails and compiled a list of 7 million individuals who have used the frowning emoticon in an email. And so he's threatening to send out these letters, the FBI. He had them mobilized, and everyone was going to get a letter. That was an outcry, right? So 1 month later, and this was January 2001, he said, okay, you got me. This was a little bit, what I'm going to do for you people is I'm going to license my trademark. So starting today, I've authorized our company to begin selling legally approved sad emoticons to the global community. Anyone who wishes to continue to use this illegally trademark logo in their email will now be able to purchase a supply from www.despair.com. And you can read the rest of that. But the whole idea is he now had a storefront that had these. And it's absolutely true story. They were available. What I love about this was there's 3 versions. You've got the classic. You had this, I think it was called Literary, and the Angst. But down here, if you look at it in the fine print, it says it's free. It's a free license. And down over here, it says this item is on back order. Right? So, but we all should have realized that it was satire because this is the same company who did these kinds of products. This is survival. Keep your friends close, but your enemies closer, especially to your friends. So it's just a very satirical company. So I think you're next.
All right. So we're going to jump into some more specifics on patents. And this is a wonky world that has many, many years of case law. You can talk about this for hours upon hours, and I got 5 minutes. So we're going to hit some of the big topics, but ask any questions along the way. Just ask. Don't even worry about it. So there you go. Thank you.
This is actually a question about something falling kind of either copyright or trademark. I'm a founder of an ed tech startup, and we incorporated almost 2 years ago under the name Meta Education.
Uh-oh.
Yeah, and our logo was just the word Meta with an infinite triangle. And we slightly rebranded so it's 2 infinite triangles that look like a letter M. You can see how that's pretty problematic right now. Mm-hmm. Still seeking funding, so we're not currently operating as a business. But the website, all our social media channels and everything has been up for about 18 months. So I guess technically some of that branding might be copyrighted, but I didn't apply for a trademark on the logo yet because we were pre-funding and I wasn't sure if it was going to go anywhere. So I'm wondering if that's like a multi-million-dollar mistake.
You're technically right. It's a copyright. You're good. On the trademark side, like Eric said, you don't have to register it. If you use it in commerce, then it is a trademark as well. And knowing Facebook and how their legal team, I'm certain that they did a global search on every single country on this earth. is meta used? Is it used in this context? Is the symbol used? Is it used in this context? And maybe, maybe they missed yours, but that's very interesting fact pattern that, it's a very interesting fact pattern that maybe Facebook might be interested in it. So no, I don't think it's a multi-million-dollar mistake, because if you're using it, it is a trademark and it's automatically a copyright. It would have been nice to have it registered, no doubt, but that's something that might be worthy of bringing up with Facebook. Hey, oh, by the way, look at this.
Okay. Well, thank you.
And I would also add, because trademark is also a deep topic, is once you have a trademark, you have to declare, if I went back up to that other slide, you would see what art units they declared they wanted to use it in, right? So you may be in the education space, and it very well may be that Facebook has not covered that particular space. So the point is that you can have simultaneous the same numbers of companies that are operating in completely different spaces, okay? Which is, I've got an example of, let's see, I can't think of one right now, but Pandora, oh, right, Pandora the jewelry and Pandora music. That's a perfect example. So thank you very much. Good. This is an interactive session, y'all. Okay. Go ahead.
All right, so go into patents. We're just going to hit some of the key highlights, ask questions. So what's protected? We talked about it. It's any idea, basically. There's a lot of different things can be protected. I'm going to say this, and Eric's going to cringe. Almost anything under the sun can be protected under a patent, but not necessarily, because we'll get to this, what's not patentable. But all those ideas are patentable. All those devices, compositions, processes, methods of making, method of using, criteria for protection. This is Legalese 101, but is it new? Is it useful? And is it obvious? I'm not going to get into that too much. Is it new? Is it different than what's out there? Is it useful? It's going to be useful. You're going to create a company on it. Is it obvious? It's a subjective term. How different is it than what's already that's out there? To obtain protection, this is kind of key, like copyrights, you don't have to file, trademarks, you don't have to file, patents, you have to must absolutely file, and if you don't file, you're going to lose your rights. So you're going to have to file. The problem with patents compared to trade secrets, which you don't have to file, you don't want to file, and if you file, you're making a big mistake. Copyrights and trade secrets is patents are probably they're most complex, and they're the most costly by a lot. A patent application can typically run $8,000 to $15,000, $8,000 to $12,000, $8,000 to $10,000, depending on the technology. And I say 8, and I know there's some big eyes, I get it. You can go to other places and it might be 2 or 3, just be careful, because this is your IP, and if it's going to be patent-based, you want really good patent applications. So you oftentimes get what you pay for in the patent world. So be very, very cautious of getting a bad patent. Don't be up at 2 in the morning eating ice cream and see invention.com, call me right now and I'll file a patent application for you. That's very dangerous.
So the money that you pay for a patent, does that go to the government? Does that go to a lawyer?
That's a great question. So you'll have Norton Rose, that's where I work. You'll have attorney fees, which that's the $8,000 to $10,000, $8,000 to $15,000. You will have USPTO fees, which can be for entrepreneurs, startups, it'll be less, but it could be $700, $800 just to file the patent application.
Cool, thank you.
Yeah, good question. So this is the one thing I tell people that are new to the game, or that want to try to reduce some costs. There's great resources out there. USPTO.gov, that can give you access to any U.S. patent or application, any U.S. patent that's issued, and any patent application that's been published. And you can search it through Boolean searches, you can search it through title searches, through applicant or assignee searches, through ownership searches. It's a great database. Another free database is lens.org. I love that one. It's the same thing. You can search all patents and applications and a lot of different biologics as well. Another fantastic one that we should all know about is Google Patents. That's probably the one I use the most. I'll just put in the patent number and I hit search and it shows up and I can create a PDF. The beauty of those 3 things are absolutely free. And if you get good at them, you can be just as good as I am after 20 years on searching to see if your idea is patentable or not. Those are the only databases you need to figure out whether your idea is patentable almost. This is the big one. It's a monopoly. It's a monopoly on what? Anybody have an idea on this one? You get 20 years when you file it. So I want to like, what's it a monopoly on? What if you get a patent? What if you get a patent on the chair?
Like you will own all the rights of manufacturing, producing this patent for 20 years.
Close. It's a weird concept. It's a negative right. You don't actually have the right to use your idea if you get a patent. You have the right to tell other people, don't use my idea for 20 years. You don't have the right to use or sell or make your chair if your chair is your idea.
I heard about this in the pharmaceutical world. I'm a pharmacist, so we know when we produce a new medicine, produce a new medical components, like as Pfizer did with the Viagra.
Yes.
Like you can't make as this components for 20 years. Either if they share their patent or for like a percentage or something.
So here's the idea that on the negative right concept. Let's say you have a patent on the chair. You get the patent on the chair, and everybody loves the chair. You can sit down. You don't have to stand all day. And then somebody comes up with like multiple screens. And if you're using your chair, you got to hop your chair around, right? Because it's static. It's just got 4 legs. I saw that over there. You see the swivel chair? I was going to bring it over, but I don't know if I'm not going to bring it over. The beauty of the swivel chair, you can sit in the chair instead of hopping around to screens. What can you do? You can swivel, right? Yeah. So the swivel chair is different than your chair idea, right? You got the patent on the chair first. You got that. I come up with a swivel chair. I see your idea. I'm like, I like it, but I can make it better. I'm going to make it swivel. I can get a patent on the swivel chair. Yeah. So if I get a patent on the swivel chair, I come second. That doesn't give me the right to make, use, and sell my swivel chair because you've got a patent on the generic chair. Yeah. It gives you the right to tell me to stop using your chair, but everybody's going to want to use my swivel chair. Everybody's going to want to use it. What happens if I create a swivel chair and I don't file a patent application on it? People are going to copy it. Yeah. My idea goes away, so I got a patent on it. I attended this presentation. I got a patent on the swivel chair. I can't use it because you got the first patent on the chair. So what happens? Because your company's going to suffer because I got a great idea. My company's going to suffer because you've got a great idea. We talk and we do cross-license deals. The idea of that story is I want to illustrate when you get a patent, it doesn't give you the right to use it. It gives you the right to tell other people not to use it, and you have to watch out for third-party patents as you come up with your ideas. Those are those great databases to see if your idea is new, if there's other patents that are out there.
Interesting.
Yeah, it's a complex thing, but it's pretty cool. This is what I was talking about with Eric on cringing. So what's patentable? I think almost anything's patentable. There are certain concepts and ideas that are not patentable. Something that's impossible is not patentable. Perpetual motion machine. I've been reading thermodynamics. You can't have a perpetual motion machine because you have conservation of energy, right? So you can't just have something completely creating its own energy because then it's creating energy. Well, it's like our first law of thermodynamics doesn't work. Laws of nature, Newton's law of gravity, well, that's not patentable. No. CRISPR, the idea of having gene scissors to go in there and cut specific parts of DNA, that alone isn't patentable because it's from a bacteria, right? That's not patentable, but if you leverage a law of nature to something that's useful, that's not out there, then it becomes patentable. What if you use CRISPR to treat a specific disease? The law of nature, CRISPR might not be patentable, but its use to treat something else, that might be patentable. So laws of nature on their own aren't patentable. Mathematical expressions are not patentable. Energy mass equivalency, what is this? Pythagorean theorem. Ideal gas law. Not patentable. But if you come up with a law of nature and you figure out a new way to use it for benefit in society, then it becomes patentable. Okay, let's go on to the next one. I know we're probably running out of time. Any idea on patents? That's a big one. Any questions? None.
5:16.
Okay, we got some time. So in one, go ahead. Yes. No, please.
What about the patent of services? Like,
I'm going to switch off of that so you guys don't get to see it yet.
what about the patent for startups that do services, not products? As in my back home, we do a pharmaceutical recruitment platform, and it's the first of a kind. There is no pharmaceutical recruitment specialized in pharmacy. So can I make a trademark of my service so the normal recruitment agencies can do my model in the pharmacy. So I will say, this is mine.
So
What do you think?
I think that's a tough one in today's world right now. It's a loaded question. It's called 101 patent subject matter. And if it's something that you can do in your mind and you can also do it on a computer, it's hard to patent right now. But I'm going to take a big step back and say, if you have a new idea and it makes things more efficient, go ahead and consider filing a patent application on it, because laws change. So what you said is a new idea, and you will talk with a patent attorney and say, this might not be patentable now, but let's file a patent application on it, because what happens in the US might be different than outside of the US as well. Yeah. Yes?
At what point are you or your idea protected, from the point you apply or from the point that it becomes approved?
That's a good question too, and this is where clients get antsy about it. It's a really, really good question. I wish I could say it's exactly when you apply, but in the US it typically is not. There's some nuances to that, but overall, no. You have to wait till it issues as a formal patent. So you file a patent application, file it with the patent office, and then you say, please give me a patent. And their typical response is, no, we're not going to give you a patent because that thing's known, it's used, it's obvious. Everybody knows that that's not a good idea. That's almost always what happens. And then you have your attorney come back and say, you're wrong, examiner, this is a really cool idea. And look at this case law that suggests that it's a cool idea. Look at this data that suggests it's a cool idea. And you go back and forth with the patent office and you ultimately get a patent. It's when you get that patent is when you have a right to go out and tell other people to do what? Not use your idea.
Mm-hmm. What's the average length of time for that process?
A great question. USPTO.gov has this whole web page, and it tells you the average length of time of almost everything. It's a beautiful data page, and it depends on the art, but I would say anywhere from 2 years to 3.5 years. I know.
Yeah, and on that, if you go and you look for dashboards, they've actually got a really great dashboard. It's all visual. And they put a lot of money into sharing, having a transparency for everyone. You can find out when the first pendency or the first ALPHIS action is issued to the time what's the legal terminology, the disposition, right? Whether you either get an issued patent or it doesn't go anywhere. So.
Yeah, but 2 to 3 years. Other countries, you can file and register it immediately, but not the US. All right, so this is kind of the fun stuff. You guys have been interactive, but we're going to keep going to the interactive because it's fun. But before we do, we got a great question here. I know it.
Oh.
So, the 2 to 3 year publishing speed and stuff, I've heard about like expediting the process. What is there to know about like the fees in terms of like expediting? So that you can get that within a year's time.
This is a loaded question too. So typically 2 to 3 years. Great question. So you can go fast, and you have to pay money to go fast. And for entrepreneurs, smaller companies, it's $2,000 to go really, really fast. And it's called expedited examination or track 1 or priority examination. And if you want to do that, it's $2,000. And check this out. Like Eric was saying, the dashboard, 6.7 months from filing to issuance. It's crazy. It goes really fast. The other beautiful thing about track 1 is, listen to me on this. So when you file a patent application, you can get a primary examiner who knows what they're doing. You can get a junior examiner who doesn't know what they're doing. The junior examiners are difficult because they're just fresh out of law school, and they want to reject everything and cut their ground and show, look how good I am. Primary is like 20 years. I've been doing this for 20 years. I know what's patentable, what's not, and I'll let certain things slide, and I won't let certain things slide. It's easier to work with me because I'm more experienced. It's harder to work with, and I'm not knocking junior examiners if you're in here. It just is what it is. When you do track 1, when you want to go fast, you will get a primary examiner every single time. That's a big value. I'm a big proponent of track 1. We can spend an hour on this, but I'm a big proponent of track 1. All right. So let's see what you guys think. I can describe it a little bit. So it looks like basically a rectangular piece of paper, and it's got pressure-sensitive adhesive on one end. What is it? Is it patentable? What's patentable about that? I don't know. You get to put it on your little thing there and see what comes up there. I do know. Can you describe it again, please? No problem. Just think of a piece of paper that's a rectangle, and on one side of it, it's got pressure-sensitive adhesive or glue, and on the other side, it might not have anything, but you can push one side to the other side and create a ring. I'm giving you a lot there. The adhesive could be patentable, I like it. That's hard to be, what? What does TBH mean? All right, label tape, that's a good one. It's easy to dispense. That's actually kind of close, actually, kind of. All right, you can stop. This is gonna like blow your mind. And every single time I go out to dinner, it blows my mind because somebody made boatloads of money on this. And check this out, it is still a live patent. No, it is still a live patent. It is still a live patent. It's still active as of today. See, it's like this build up, but now you gotta. What is it?
What is it?
Yes, the napkin thing. That's the way I describe it. The napkin thing, the little ring around the napkin. Every time you go out to dinner, open that bad boy up and look inside. There's a patent number on it because somebody's making money on a very simple idea. It's a patentable idea. Thank you for saying that. That's my reaction too. But so this is the whole. But this is the whole point: is if you have an idea, you got to think of IP. Because would you have copied this if you were somebody else? If you were 3M, I would have been copying that. Everybody wants to use it. Everybody does use it. It's a simple idea. It was a patentable idea, and they're making a lot of money on it to this day.
So then do they get licensing for it, or somebody has to pay them because they use it, or?
You answered the question. Yeah, they get licensing revenue. You don't have to get permission for it, and if you don't get permission for it, they're going to come after you and sue you, like Eric said. They're going to say, I got a patent on it, and we've learned I don't have a right to use mine, but I have a right to tell you not to use my patent. And that's what they do. Crazy little idea, right? Build a company on that. Here's another fun one that everybody knows. In one word, what's patentable? So I can't see it up here. If you don't have a phone, it's the iPhone, and it's kind of like drawn in black and white, and there is some dashed lines. What's patentable about that? You can say almost anything here. It's a brilliant company with just amazing IP. Yeah, I agree. Agreed. Well, you know what? Whoever said dimensions, let me throw this out at you. It is just a rectangle. So, came out in 2007. It was a rectangle back then. Mine's like 3 or 4 years old. It's still a rectangle. But the dimensions are interesting. I think you're really onto something. Full protection, case cover, surface, all of this. So we're going down a different path this time. I'm taking a different way. We have something in the world called design patents. So I'm talking about, like, what's your idea, the napkin ring? What's your idea, the new data that you're going to come out with? What's your idea, CRISPR? What's your idea, a method of treating, a skin disease? This is different. So Apple does the utility patents. They come up with everything you said, the material used for the screen, the case cover maybe, but they also protect. Think of Jonathan Ive and think of Steve Jobs back in the day. They protect the beauty of the elegance of their products, and they protect that through something called a design patent. And here, it's a kind of a brilliant. Whoever drafted this is an amazing design patent attorney. It's a rectangle. You got the home button. Get the little speaker up there. And then you got the screen, and on either side of it, if you remember the old iPhones, you got the black bar and the black bar. All these dashed lines mean nothing. They're not claiming anything. All they're claiming is the top surface of like the iPhone 2 or 3 or whenever it was. And they got a design patent on that. So is that valuable? Anybody want to take a guess? How valuable is it? Because there's an actual number you can put on this one. They sued Samsung for $1 billion and won.
$1 billion.
Yeah, it's like, what's the Mike Myers thing, right? $1 billion. So design patents is another way to protect products. It's the look and feel. If you want to protect the look and feel of that laptop that you're using right there, it could be a design patent. If you want to protect the utility aspects of it, the material of it, you can see the Apple right through there, then maybe that's a utility patent. But you can protect the look and feel of an actual product through a design patent. And they are wildly valuable, $1 billion.
So I believe I've also developed software, and I think I've been told it falls in this gray area. It's really hard to patent the thing that we're doing. How would you go about like disproving that it is patentable before I don't do that? Does that make sense? Like, is it just me Googling on my own? Do I pay someone for their advice before I file the application? Like, right? What?
I got to go back. I got to show you because that was the whole point of that. So great question. A great question. You might want to pay somebody a couple $1,000s to do a search and analysis to see if it's patentable.
Right. I can search all day long, but I don't know what I'm
I'm going to empower you right now. I'm
Okay.
empowering you.
Yes.
Google Patents. Go to Google Patents. It's a simple interface. Just put Google Patents in the search bar. It'll come up Google Patents. And whatever your idea is, close your eyes, think about it, imagine it, and come up with words to describe it and put it in that search bar, and you will get hits on what's already out there. And you can look to see if your idea is out there. If you see something that's out there, no good. If you see that nothing's completely on, we know it's new. And then when you get past new, how different is it, is what you're getting at? It's subjective. Once you get past new, I feel like you want to get close to thinking about filing something. And the reason why is it is subjective. Is it obvious? Is it unique enough? Is it subjective? It's subjective with the patent office. It's subjective with me. It's subjective with you. Get past the newness. Is it new? Yes. Then I think you have a shot to file a patent application on. That's not an easy answer to that question, and it's not an easy question to answer either.
Right, because it's like, what if you're not using the right word searches? What if I lack imagination in what
So
I'm
that's where
searching?
you have that's the point of that. So that's where ask the experts too. You're going to have to maybe get a patent attorney to do that because they do it every day. I do it every day.
Right, it'd be like, help me figure this out before I file.
Yes, but you can do it yourself too when you get good at it. All right, I think you're up, Eric. Let me make sure. Oh, wait, no, I've got trade secrets. We'll roll through trade secrets fairly quick.
Yeah, since there's been great questions in the audience, we may dispense with a couple of these slides.
Okay, I've got to do this one just really quickly. This is a fun slide. This is more examples. Monopoly was patented in 1935, and it was a utility patent. That's brilliant. Monoclonal antibodies, I'm not going into them. I know Rob can do them like the back of his hand, but basically patented in 1979, and every other commercial is Humira. Every other commercial is some monoclonal antibody that reduces TNF-alpha expression and reduces inflammation. It reduces IBS, it treats psoriasis. You see those every other commercial. That's a monoclonal antibody. It's billions upon billions upon billions of dollars. Is that IP valuable? Heck yeah, it is. Billions of dollars. This is a beautiful one, UT Health Science Center, San Antonio. But still, UT Health Science Center, San Antonio. Julio Palmez comes up with the stent. University developed. Universities are brilliant at developing ideas. You're not encumbered by trade. You're not encumbered by price, the price of your stock. You're not encumbered by, you're not encumbered by company logistics and I want to increase profits. You've got ideas and you're trying to protect the ideas. The stent came out of UT San Antonio. It's awesome. They sold it to J&J for $500 million. Is it valuable? Yeah, it's valuable. And it wouldn't have been valuable if they didn't have a patent application on it. CRISPR is the newest thing. It's the scissors to the DNA of our life. And there's a big patent war going on right now. Who invented it first? Is it UC Berkeley? Is it Broad Institute? And that's going to be going on and on. Why are they fighting over that? Because what? It's extremely valuable. So I love that. That's a great slide. That's Eric's slide, and I think that's an awesome slide. So trade secrets. Let's just kind of quickly go through it. Here's the number one thing. If it's not a secret, it's not a trade secret. Right? That answers your question. If you come up with some new algorithm and you want to publish it, go ahead, but it's gone. So if it's going to be gone, file a patent application on it. But if you don't file a patent application on it and release it to the public, it is no longer ever going to be a trade secret again. So the thing about trade secrets, it has to be confidential information. You have to just be reasonable about trying to protect it, maintain it as a trade secret. And does it have value to the company? We know it's going to have value to the company. If you do all those three things, you have a trade secret. You don't have to file on anything. It creates automatically. So that's IP right there. I've done so many due diligence with large companies and with small companies. Trade secrets are highly valuable in these due diligence efforts, especially with small companies. If you've got certain know-how that others want, it becomes extremely, extremely, extremely valuable. Extremely valuable. Think of, so trade secrets, ideas, creation, anything. Just think about information, data, processes, customer lists. All of that is trade secretable. Some famous ones, we'll go through them quickly. My kids eat these every single morning. I love them too. So it's a trade secret, the nooks and crannies, surface area, surface morphology. There's actually a certain way to make it, to bake it, to create it, to get the nooks and crannies. They don't publish that. Google patents, PageRank. Google patents, Google PageRank. The algorithms, trade secret. They're not going to publish that, trade secret. The beauty of trade secrets over patents, if you can keep it a secret, it goes beyond 20 years. It goes forever, right? It goes forever. Coca-Cola. It's been around since, what, the 1800s, 1900s? It's still a trade secret. There's a lot of different trade secrets. Where do they get the vanilla extract? What's the exact formula? How they make it? KFC, 11 herbs and spices, trade secret. And they even leverage that to like buy it because everybody wants a trade secret. Everybody wants a secret. Everybody wants the secret sauce. Buy it. So I think that's all I got for trade secrets right now. You can spend an hour on this, but.
I'll also make one more comment for the faculties in the room. Here at the University of North Texas Health Science Center, we don't really have secrets, right? So in your normal course of your research, you would have your surprising results, or you have anything else, and we would have you would have know-how, which is protectable, which is walk away. It's another type of trade secret, really, and that is like how to operate a particular instrumentation, or how to set your parameters so that you get a particular result. And that is all, it can be explained in patents if it is patentable, but also it is, we would have, best practices written down in procedures. So I just wanted to, it's really interesting because in a university environment, we're about academic freedom, and we're about, this is more kind of the protections in industry. I just wanted to make that clarification. All right, and this is me, so this is a good time. And I'm going to really fly through these slides because I know we're getting close on time. So when do I disclose my IP to others is the next question. And basically, the takeaway message on this slide I want to leave you with is always disclose before you, always protect before you disclose. Because you can endanger yourself, you can lose either intentional, you can lose your rights to your intellectual property. And typically, these are some of the places that you would encounter as companies in speeches or demonstrations and marketing, technical papers, third-party companies or contracts, in any kind of discussion, right? Offer for sale, that's a big one. You might be have a product, and you might be talking about how you might have this next product. In the U.S. patent law, you have a clock that starts on when you can patent, right? One of those requirements are offering it for sale. If you've got something, you're talking and you're offering it for sale, that will start a clock on when you can patent. So a lot of these things you might not think about, but you just have an awareness of when you can disclose. Companies will want to pitch their ideas and their services to venture capitalists for funding, right? So pitch deck materials might contain intellectual property. And so you might want to develop a non-confidential pitch deck and a confidential pitch deck for further involvement. So you do not, as Mike had previously said, you don't include, you just don't do it. You don't put trade secret information. You don't put the secret sauce in a pitch deck. But you can communicate your idea in a great way, usually with non-public information. If you are going to have an event, or if you're going to have a one-on-one with someone, it's a good idea to do it under a confidential disclosure agreement, which basically says that we're going to have a discussion, and these are the topics that are going to be covered. And what I'm going to tell you during the course of this conversation is going to fall under confidentiality. Okay. And there is, a litany of things that can be in that confidentiality, right? like in the event of if you verbally disclose something, or if it's if audio tape, that can be disclosed as, typically you want to reduce it down to writing so that you can stamp and mark it and then you have a date on it. Should I develop an IP strategy? Well, this one's a pretty easy one. Yes, you should. So next slide, right? No, I kid. We have, of course, you should develop an IP strategy. This goes back to doing your due diligence, identifying what you might have in your company, which might be protectable. Once you do that, then it's a good idea to develop some written materials, right? So in your company, you would want to say, here are the parameters around disclosing the type of intellectual property. And then you can identify the patents, the trade secrets, trademarks, and copyrights. And then, let's be honest, we're all going to want to attract, if you're a company, you're going to want to attract investors, but you're going to want to do it in a way that you don't give away your rights. You do not want to become the R&D team for your competitors, right? So you can increase your value by ensuring your IP protection for all ideas. It goes back to leverage. So if you have your IP in place, or if you've got your protections in place, you now have the leverage for your venture capital, and you put you in a better position. And then I'm going to skip that. Now, do you want to do the top 10?
Do we have time or not?
What is the time?
Do we have time?
5:38. Okay. I think we should dispense and we should wrap right now since we're already over time. And I appreciate everyone staying for the duration of this. But okay. Okay. So my commercial right here at this point is, if you do stay to the end, there will be drawings. Okay.
So I've created a couple of top 10 lists, and there's nothing in order here. There's a third top 10 list, but these are the big ones for me. So this is for entrepreneurs, and just kind of think about them. I'll run through them quickly. We don't have to spend too much time, but if you have a question on them, hey, so is this available? Is the presentation available as well online?
That's a good question.
Make sure it's available online and get it online, because these lists are actually really important, in my opinion, for entrepreneurs and young companies. So I hope it's online. If not, email us, and I'm happy to send you these lists. I have no problem with it. So look how tiny they are. So they tell you, like, when you do presentations, don't do like a slide that's got a million little words on it, right? I could sit here and just read the slides, but I'm not going to. These two are worth every word, I think.
Entrepreneurs are rule breakers anyway, so you're in a good group.
So get professional help. I'm not kidding about that. Do what you can do, but it doesn't take a whole lot to find like a smaller firm and just ask for some help. And they'll give you almost every single patent attorney I know, good ones and bad ones, will be good about giving you help, because we kind of care. So like people say, oh, you're an attorney, and they look at me like, oh. I'm like, no, I'm like the least threatening attorney around. I'm a patent attorney. I just like ideas. Get professional help. Business structure, you guys should know that, but right, protect your individual assets. Do an LLC, do it as a company. Insurance, get insurance for your business if something goes awry. It's not a big deal. Create employment agreements. 4 is a big one, guys. If you have yourself as an employee, fine. If you have somebody else you add, get an employment agreement and talk with an attorney. Why? Because you can have intellectual property, IP provisions in the employment agreement. Those are so key when you go to due diligence and you do mergers and acquisitions and investments with companies. Employment agreements are wildly important. But check this out. We're in the age of Google, right? So just look online. You can get sample employment agreements, and most of them are going to be pretty good. Employment agreement. Put everything in writing. I know everybody's like, oh, yeah, we're cool. I'm good with you. You're good with me. We know each other, so don't worry about it. We don't need it in writing. So they made a movie about this. It's Facebook, right? The Winklevoss twins and, Mark Zuckerberg. Put it in writing. There's nothing wrong with putting it in writing, and nobody's going to be offended if you say put it in writing. So don't worry about saying I want it in writing. It's not offensive. We've just spent the last hour and a half on 6. I'm not going to go into that. It's wildly important. Respect the IP rights of others. So that was the question. Go to usbto.gov. Does anybody else have it? Go to Google Patents. Go to lens.org. You can see if third-party patents are out there, and Be honest about it. If your product infringes, maybe you need to talk with those third-party patent holders. Maybe I need to talk with the shareholder and we come up with an agreement. So respect the rights of others. When you're in investments and when you are in mergers and acquisitions and these big companies come in, they like to see that you've looked under the tires and you do indeed respect the rights of others. Independent contractor issues, buy-sell agreements, fundraising, investing. All three of those are wildly important. I know we're running out of time. On the independent contractor issue, it's the same thing. Put an agreement in place. Who owns the IP into that situation? Make sure you own the IP. Make sure you own the IP. Buy-sell agreements, that's probably not the best one, but you know what happens if you exit the company? You should have something in place for that. Fundraising and investing. So you guys have to figure this out. I'm not good at this. I've talked with other people from 3 people at the Pickle Research Center in Austin, and now they're a massive company. And you lose a lot of your rights. You lose a lot of your value. You lose a lot of your ownership with each individual round of investing. So be wary of that. The other top 10 list, this one's even more important. So this is pretty cool. This is wildly important, guys. These are the big agreements that you have to worry about as a small company and a large company. All large companies have these agreements. I want all the small companies too as well. And you can go online and find most of these things. A license agreement, that's me and you talking about the chair. That's me and you talking about the swivel chair, right? Assignment agreement, maybe I want to give my IP rights to somebody. Well, there's provisions in there to do that, and how much money or what are you going to get back if you're going to give something to somebody. Employment agreement we talked about, that is a big one. Consulting agreement, this is another big one for entrepreneurs, right? You talk with somebody else and you want to get their ideas. Who owns the IP when you start consulting? It's all in these agreements. Non-compete agreement, maybe your employment agreement has a non-compete clause, and if your employee goes to another company, they can't do so in the same area for 2 years. Think of non-compete agreements with your employees. Supply agreements. Supply agreements are wildly important, right? The supply chain. In this day and age right now, what's going on? There's a big mess. My wife has this skincare product she loves, and they don't have any products right now because there's supply issues. So this is like Eric's wheelhouse here, sponsored research agreements. Like typically you work with universities and you want them to do some research. Who owns the IP? I represent a lot of entrepreneurs and companies and we own the IP, and Eric and Rob are like, no. The university owns the IP, and it's a battle back and forth all the time. Joint development agreements, it's kind of the same thing if you're gonna work with another company. If you're going to work with another individual, if you're going to work with a university, and you're going to jointly develop IP, who owns that IP? And the crazy thing is I've seen it with large multinational corporations violating this, not understanding this. And there's a question of, hey, Mike, can you look at this today? It should only take you an hour. And it's like 3 weeks later, yeah, I actually think they own the IP because nobody put an IP clause in the joint development agreement. Confidential disclosure agreement, non-disclosure agreement. That's probably the biggest takeaway for the entrepreneurs today. You're going to have to share a lot of your ideas to get investors. You're going to have to. Protect yourself while you do that. Non-disclosure agreement, confidentiality agreement. You can look those up and have good 1-2-page agreements that a lot of big companies will sign.
Are you saying have a combined one, or those are two separate? We use NDAs a lot, but I've never...
It's the same thing. People will say confidential disclosure agreement or non-disclosure agreement. So it's kind of the same thing. I just put them up there. Go ahead.
Go ahead.
Then the last one is material transfer agreement. Maybe not for this crowd right now, but if you have material and you want it to get looked at by the university, maybe you're a biologics startup company and you've got some new material and you want to send it over to the university and they want to look at it, tell them don't break it down. I don't want you to reverse engineer it. I don't want you to create IP on the stuff that I give you. That's kind of the idea of MTAs. So those are really big. So I would say for this crowd, the big ones really are going to be number 3. I would say 4, potentially 5, and definitely, 3, 4, 5. All right, that's what I have.
Okay, let's, let me have that.
Oh, you've got some other stuff.
Yeah, we're gonna wrap. We're gonna come to the end here, so we're not gonna do this last poll, but I want you to think, just if you could think in the back of your mind, what was the one thing you learned from this session, and just shout it out. So I have an idea that you've learned something new. And now if I ask you that first question in the very beginning, we would have 100% that I've heard something during IP, right? So if I could have Amber, could you bring those items up here? Amber's going to assist me. Amber, everybody, she works at the University Health Science Center, and she has been an instrumental person, along with Kendall in the room. Raise your hand, Kendall, because you should be recognized as well. Darlene also works with us in the back. Darlene, you can raise your hand. And then our leader is also in the room, and I applaud him from staying here for the entire time. I appreciate that, Rob. Dr. Rob McLean is here as well. And with all right, so where is the drawing? Can we also have the cup? Okay. All right, very good. I appreciate everyone's time and attention this evening, and without further ado, actually, you do the drawing. That way, it's impartial.
Unbiased. I know no one.
So the first one is.
Which side is?
We've got 3 lovely prizes, and we're going to do. The first person who gets the first one, you get the option of one of the 3 choices. So if you're holding 6, great. Come on down.
How do we know if it's 6 or 9? Your torn edge is on the right.
Oh, so this isn't like Uno, so there's not a lot. So yeah, so you please pick one. You've got the first one is a book from. This is the Startup Community Way. Ian Hathaway was our guest speaker, our keynote last night or yesterday, and this is a great. He called it, or some other people call it, the Bible of Startup Community. So there's that one, or you can choose one of the other 2.
Goodie bags.
Yeah, the other ones are goodie bags. So, all right, good job. One more or 2 more?
10?
10? Great. Come on down. So these are swag bags is what I'm going to call them.
15. That's you?
Great.
Awesome.
Yep. All right. Great. There you go. So much. I just want to thank everybody one more time for coming. And I'm going to leave you with this because we're about innovation, and also I think this is apropos. This was also one from Despair, and I loved it so much. Innovation, if it could make your job easier, it could make it irrelevant. So.
Let me just say a word or two for those of you entrepreneurs in the room. We're here to be a resource for you. If you heard something that you got questions about, you want to know how to use these tools or these agreements, then come by and see us. We offer it right here, and it's as accessible as this space looks all the time, maybe with a little different furniture, but stop by, shoot us an email, give us a call, just drop in. We'll show you how we use lens.org, other things like that. So that's one of my favorites as well. So please consider us as a resource in your efforts to build a successful company. So.
All right. Thank you, everybody. Have a great evening.